Good afternoon and welcome. Welcome to the investiture of Professor Colleen Murphy as the Roger and Stephany Joslin Professor of Law. It's wonderful to see so many friends, colleagues, and students here to celebrate this significant and happy occasion. And I know some people are joining us online as well, so welcome. We're glad you could join us. We especially want to welcome Colleen's family and friends who are here with us today. I also know Dean Amar sends his welcome and is sorry not to be able to be here for this part of today's celebration. Investitures are a long-established tradition in academia to acknowledge and honor faculty members who, over the course of their careers, have shown exemplary achievement in their scholarship, teaching, and public engagement. And investiture as a named professor honors the highest levels of such academic accomplishments. These professorships are a testament to the college's world-class faculty, as well as the magnanimous support of our alumni and other donors. And in addition to celebrating our honorees and their family and friends, investitures give us a chance to also honor our donors whose vision and generosity make such events possible. The Roger and Stephany Joslin Professorship in Law was established in 2011. Roger, who passed away in 2014, was a member of the class of 1961 and graduated magna cum laude and Order of the Cross. Stevie is a civic leader and philanthropist in the Bloomington Normal community. She's joining this event via live stream. So let us thank her for their thoughtful support and for celebrating. We are delighted to be joined by two distinguished campus leaders today. We have Dr. William Bernhardt and Dr. Investiture Patton. William Bernhardt, the Vice Provost for Academic Affairs, provides leadership in the areas of academic and faculty affairs. Please join me in welcoming William Bernhardt.
Thank you, Verity. It's great to be here, and I'm honored today to represent university leadership to celebrate Professor Colleen Murphy as she's invested as the Roger and Stephany Joslin Professor of Law. And on behalf of the Provost, let me offer my congratulations to Colleen on this richly deserved recognition. It's so wonderful to see us gathered here together in person for this celebration. I think one of the things that we've learned over the course of the last 18 months is that we can't take for granted our intellectual community. The energy, the vitality, the inspiration that comes from interactions with colleagues, friends, and students. These investitures are such an important part of that intellectual community. They offer us a moment to celebrate our colleagues, recognize their contributions, and simply say thank you. Thank you for making our institution a better place. And certainly, when we think about Professor Murphy's lengthy accomplishments, it is evident she deserves our appreciation and gratitude in doing so. These investitures also offer us a moment to reflect on our shared purpose, our common vision, and what we value as an intellectual community. And when I think of Colleen, and I think of her work and her contributions, I think she exemplifies at least three of the things that we highly value about being here at the University of Illinois. First, as you all know, we're a land-grant institution, and that means we have a responsibility to serve the community, the state, the nation, and the world. As faculty, that means we have a special responsibility to engage in scholarship that addresses important societal issues. And Colleen's research certainly does that, speaking to fundamental issues of justice, risk, fairness, and equity, foundational concerns that societies must consider in making political and policy decisions. Second, Colleen's work is profoundly and deeply interdisciplinary, something else that we pride ourselves on here at the University of Illinois. Her ability to transcend disciplinary boundaries allows her to draw on the power of different intellectual traditions to arrive at deep, non-intuitive conclusions about these challenges. And third, I also want to note Colleen's commitment to service on our campus and in the academy. These service roles extend her impact and allows her to connect with colleagues, students, and community members well beyond the classroom. Really, she is a model for how faculty can contribute to the success of the University of Illinois and its land-grant mission. Our land-grant mission also influences alumni and friends of our institution. Our alums recognize how the university can play a transformational role in society. They want to invest in the people and programs who advance that mission. As a university, we rely on the generosity of families like the Joslins, families who appreciate the transformative potential of the University of Illinois and recognize that an investment in the university will have a deep and lasting impact for generations to come. We are so grateful for the resources that they provide to keep our intellectual community going and allowing us to pursue excellence in scholarship, research, teaching, and outreach. We could not be successful without their kindness. So let me just one more time offer my congratulations to Professor Murphy on her investiture. This is perhaps the highest recognition we can provide to a faculty member. We celebrate your accomplishments today, and we look forward to even more in the future. Congratulations.
Thank you. Also joining us today is Investiture Patton, the newly appointed Harry E. Preble Dean of the College of Liberal Arts and Sciences. This, to give you a sense of the position, this is the academic home of roughly a third of the faculty and students at this university. Please join me in welcoming Dean Patton to the law school and to Illinois.
Thank you, Associate Dean Winship. Hello, friends and colleagues. It is wonderful to be with all of you today for this happy occasion. As Verity said, I am Investiture Patton, and I am Dean of the College of Liberal Arts and Sciences and a professor of English and African American Studies. This is my first semester at Illinois, so I am delighted to have the opportunity to visit the College of Law for the first time. Thank you to Dean Vickman Amar and Assistant Dean Carolyn Turner for the invitation to speak today. Participating in investitures like this one is truly an honor for me as a faculty member and as dean. Investitures and the endowed positions they celebrate reflect all that is great about the University of Illinois: accomplished faculty, talented students, supportive family and colleagues, and visionary donors. Another hallmark of greatness, and one we take very seriously at the U of I, is collaboration and interdisciplinary work. Strength and vigor in one's disciplinary pursuits are, of course, very important and foundational to the teaching, research, and outreach mission of our university. But the ability to take one's expertise and bring it to bear on other areas allows us to open doors and pursue new knowledge and solutions. Interdisciplinary work has an incredible amplifying effect. It's part of what we're known for at Illinois, and it's something Professor Murphy does exceptionally well. Colleen's CV tells the story of a scholar committed to working across boundaries. She holds appointments in units across campus, including law, philosophy, and political science. She is an affiliate of the Beckman Institute for Advanced Science and Technology, the Center for African Studies, the European Union Center, the Program in Arms Control and Domestic International Security, and the Initiative in Holocaust, Genocide, and Memory Studies. She directed the Women and Gender and Global Perspectives program from 2013 through 2020, and currently serves as the acting executive director of the Illinois Global Institute, a unit within the College of LAS that brings together 10 global studies centers and thematic programs and serves all of campus. Colleen is also the Humanities Research Institute Andrew W. Mellon Faculty Fellow in Legal Humanities. That is just a long list. I got tired just reading that. But you know, they say busy people do a lot of stuff, and I think she's a prime example of that. Colleen is a scholar and teacher who specializes in moral, political, and legal theory. She focuses her research on political reconciliation and transitional justice. Colleen uses her boundary-spanning expertise to create connections between numerous disciplines, including politics, economics, philosophy, law, engineering, climate science, ethics, human development, sociology, and many other fields of study. In addition to being an outstanding interdisciplinary scholar, Colleen is a strong leader and an exceptional member of our campus community. Although I have only recently met her, she is also clearly a delightful person and a valued colleague. Colleen, I am grateful for you choosing Illinois as your academic home and for all of the many contributions you make to the College of Law, the College of, my goodness, I'm forgetting the name of my own college. That's because I'm so new and so green. The College of Liberal Arts and Sciences, and of course, to our entire community. Congratulations on the well-deserved honor of being named Roger and Stephany Joslin Professor of Law. Congratulations.
So I'm grateful for going after Dean Patton because a lot of the different pieces of the list are already out there. And so I want to say a couple of things about some of the themes I've seen in her career and her work. And then I'll add to the list because it's long. Okay, so there are a couple of more things to say. But I wanted to highlight some of the themes. And the first one is just engagement with consequential problems for society. And so not just in the US, but globally, her work really is exemplary in that way. The other is what you can tell from the list you just heard, that she has excellence in multiple disciplines. And then the third thing is just a theme carrying through some of her experiences, which is that she has a leadership role in interdisciplinary institutions across the university. All of these are valuable, and all are reflected in some of the things that Dean Patton mentioned. She's obviously a professor at the College of Law. She has courtesy appointments in the Department of Philosophy and Political Science. We've heard she's a fellow in Legal Humanities and has various executive director roles. She has been a Public Voices Fellow, an associate for the Center of Advanced Study at Illinois, as well as a visiting professor at 4TU Center for Ethics in the Netherlands. And I may be overlapping. You can tell this is a long list. Before joining us, she was on the faculty at Texas A&M University and had a Lawrence Rockefeller Visiting Faculty Fellowship at the Princeton University Center for Human Values. She has an MA and a PhD in philosophy from the University of North Carolina at Chapel Hill and a BA from the University of Notre Dame. She is a teacher and a scholar in the areas of moral, political, and legal theory. Her research focuses specifically on political reconciliation and transitional justice in response to entrenched injustice. And she also has work, as you've heard, on the legal and ethical dimensions of risks. She's the author of The Conceptual Foundations of Transitional Justice, published by Cambridge University Press in 2017. This received the 2017 North American Society for Social Philosophy Book Award, and a little bit closer to home, the Wayne R. Lefebvre Award for Excellence in Faculty Scholarship from the University of Illinois College of Law. She is also the author of A Moral Theory of Political Reconciliation, also published by Cambridge University Press. She's the co-editor of several interdisciplinary edited volumes, Climate Change and Its Impacts, Risk Analysis of Natural Hazards, Engineering Ethics for a Globalized World. She's authored and co-authored more than 60 peer-reviewed journal articles, law review articles, and book chapters, which I won't list for you, but we can look it up. And these are in prominent venues, so as you might expect at this point in the description, including the proceedings of the Aristotelian Society, Risk Analysis, and last but not least, the University of Illinois Law Review. She also has received more than $1 million of funding to support her research. And this is from the National Endowment for the Humanities, the National Science Foundation, the Qatar National Research Fund, and U.S. Army Corps of Engineers. She's delivered more than 130 invited lectures throughout the U.S. and the world. She is a respected colleague, a thoughtful scholar, an engaged teacher, and it's a privilege for me today to recognize your many accomplishments and to confer on you this honor you have most clearly earned. Would you please stand so that I may present you with a medallion marking your investiture as the Roger and Stephany Joslin Professor of Law. Please join me in congratulating her and handing off the podium to Professor Murphy.
Thank you, Associate Dean Winship, Vice Provost Bernard, and Dean Patton for the warm introductory remarks and for taking time to be here today. I'm honored by your presence. Thank you all for being here, either in person or virtually, from in town or out of town, from the law school or across campus. I'm particularly grateful to my parents, Robert and Kathleen Murphy, my brothers, Jack and Kevin Murphy, for traveling today to be here, and to Stephany Joslin for making this professorship possible and for taking time to listen in. And finally, a special note of thanks to my husband, Paolo Gardoni, and our children, Peter and Patrick, for being the rocks, big and small, that make all else possible. So here is my best effort, a necessarily simplified story of what I've been thinking about and writing about for the past 20 years and what I anticipate I will continue to think about for the next 20. So one way of understanding the questions I've been grappling with in my research is, why law? Law is not the only way to try and control behavior. Psychological manipulation is another alternative, brute force, yet another, managerial direction, in which directives are applied by a subordinate in order to serve a purpose set by a superior, yet a third. The complaints about law and lawyers are familiar. If you're engaged in legal processes, they can be slow, inefficient, complicated to navigate, expensive, and in their process or in their outcomes, unjust. And so in the face of these complaints and the fact that we have alternatives, why should ruling by law shape some of the standards by which we evaluate the legitimacy of governments? Why does it matter? To be able to answer that question, we have to first understand what law is. And the starting point for my work is a very simple and a very thin one, articulated by a scholar upon whose work I draw frequently, Lon Fuller. Law is, quote, the enterprise of subjecting human conduct to the governance of rules. Now, a set of conditions need to be met in order for that to be possible. Rules have to take a certain form. We can't govern our conduct on the basis of rules that are kept secret, and so promulgation is needed, or are contradictory, and so we don't know what to do, or tell me today what I needed to do yesterday, and so rules must be prospective. It's not only that rules have to take a certain form, but for rules, and not, for example, the whim of officials to govern conduct, it's important that there be congruence, between what rules declare and the conduct of officials and legal subjects on the ground. Fuller summarizes the social meaning we attribute to having this system of conduct in the following way. Officials say, "These are the rules we ask you to follow. And if you will obey them, then you have our promise, then these are the rules we will apply to your conduct." Now, there's two things to notice immediately about this way of defining law. First is that actual legal systems, of course, vary in the degree to which these conditions that I've briefly articulated are satisfied. Fuller noted that too. What he said was that a certain threshold level of congruence, prospectivity, promulgation, clarity needed to be in place for a community to credibly be talking about being in the law game. The other thing to notice is that governing by law on this definition doesn't require democracy or entail respect for human rights or say much about constraining the substance that laws can have. I take it to matter, following Fuller, that there are a number of different ideals and standards according to which we can evaluate the legitimacy of governance, and it's important to keep them distinct. So if we start out with a thin understanding of law, why does it matter that we govern in this way? And against the background of the complaints about laws' inefficiencies and cost. So I've tried to answer this question not by examining cases of success, but rather by looking at cases of failure. Put differently, cases in which law doesn't govern, partially or fully, more or less systematically, where the criteria that Fuller laid out have little bearing on the reality of what happens on the ground, with the thought that we can understand why law matters when we see when it is absent and what is missing as a result. So the move and the impetus to look at failure is a product of another enduring, indeed you might say obsessive, interest of mine, which is in dynamics of conflict and repression, where the breakdown of political relationships generates the need for what I've written 2 books about, political reconciliation and transitional justice. There are 2 cases that I'll refer to today and that have shaped my thinking over these many years. And so I'll just give you some brief backgrounds on very complicated scenarios so that we're on the same page moving forward. One is Northern Ireland, which is a post-colonial context in which 2 deeply divided, profoundly segregated communities live and cohabitate in a very small geographical space, defined by different ethno-national identities, nationalists who identify as Irish and are overwhelmingly Catholic, and Unionists who identify as British and are overwhelmingly Protestant, have since the partition of Ireland in 1921, 100 years this year, navigated a history of repression, discrimination, segregation, predominantly of the Catholic minority, and navigated the violent conflict that follows, known often as the Troubles. And a community whose ingenious Good Friday Agreement, or Belfast Agreement in 1998, enshrined birthright recognition of Northern Irish citizens to identify as British, or Irish, or both, and set up provisions for and achieved what in the current lingo constituted the abolition of the police. The RUC was renamed and reconstituted as the Police Service of Northern Ireland following the agreement, and which now finds itself in an exceptionally fragile moment as the UK government has chosen to interpret its Brexit mandate in a very particular way, which is simply incompatible, in my view, with the commitments underlying the Good Friday Agreement. Because that agreement blurred boundaries of sovereignty rather than hardening them, and relied upon recognition of a plurality of national identities, one of which remains ineliminably connected to the EU. And so Northern Ireland remains, predictably, the Achilles heel of Brexit. The second case that I look at is South Africa under apartheid and during its transition to multiracial democracy, a post-colonial and currently post-apartheid context in which during the apartheid order, all South Africans were assigned into one of 4 racial categories and lived lives circumscribed by a legal regime predicated on a commitment to separate and unequal, where segregation and discrimination in all areas of life, education, health, living, unemployment, and exclusion from others for Black South Africans, namely in politics, resulted in a country that was one of the most equal and unequal in the world when apartheid ended, but whose articulation of a commitment by leaders like Nelson Mandela and Archbishop Desmond Tutu as the dawn of multiracial democracy began to reconciliation, shaped in the rhetoric and in the structure of the Truth and Reconciliation Commission that was set up, conversations that continue to this day, both laudatory and critical, and profoundly influence the contours of the fields in which I work. So now, drawing on these cases, what does failure in governing by law look like? Well, in those cases, it looks in terms of partial, systematic lack of congruence, disproportionately affecting one community, Catholics in Northern Ireland and Blacks and South Africans, whose basic human rights were violated in the forms lack of congruence took. In Northern Ireland, forms including police brutality, in some cases rising to the level of unlawful state-sanctioned killing by the police in collusion with unionist paramilitary organizations, the construction of no-go areas where the police and British Army literally did not go because paramilitaries instead from the nationalist side govern. In the context of South Africa, the entire premise of the South African TRC was investigating killing, abduction, torture, and severe ill treatment carried out by South African Defense Forces and police, not exclusively, but including them, and whose report summarized some of the ways the rule of law didn't function in this way. Part of the reason for the longevity of apartheid was the superficial adherence to the rule of law by the National Party, whose leaders craved the aura of legitimacy that the law bestowed on their harsh injustice. From the mid-1990s, when a climate of state lawlessness prevailed, even the pretense of adherence to the rule of law was abandoned. So against this background, we can begin to articulate why does law and ruling by law, governing by law, in the way that I've articulated, matter? One reason it matters is because of the suffering and injustice that specific instances of incongruence generate in the forms of the killing and the torture and abduction that I just referenced a moment ago. But part of what I've emphasized in my work is that the consequences of the lack of congruence, the erosion of governing by law, are much broader and affect the entire structure and contours of political relationships in the context of interest. And there's 4 specific negative impacts that this has. And this draws on Lon Fuller and is inspired by him in various ways. The first consequence is that it erodes possibilities for the exercise of agency by members of the targeted community. Implicit in the idea of the rule of law is the thought that individuals are responsible agents, capable of understanding and following rules, and answerable for their defaults. But such agency is impossible to exercise if arrest is not a function of engaging in legally prohibited behavior, or if the consequences of arrest go beyond what is formally declared. And so in profound ways, members of targeted communities in contexts of partial legality are simply not in a position to shape how their lives go by and on the basis of how they act, with reference to what legal rules give them as guidance, because those rules aren't reliable guides for the forms of conduct they can expect in response. The second consequence is the undermining of transparency in a way that shields governments from critique and entrenches injustice. When the kind of incongruence that I've been talking about is present, and present in a widespread manner, then looking at what rules permit or prohibit is simply insufficient and unreliable for knowing what the interaction among legal subjects and officials looks like in fact on the ground. But of course, governments characteristically point to such rules. We don't permit torture. Just look at what the law says. There are no death squads. We don't prohibit them or permit them. There are no political prisoners here, to defend itself against critique. And when this gap exists, it's much harder for outside actors or inside actors to have access to the kind of information that would confirm what governing by law looks like on the ground, or whether it's in fact present. There's an additional factor in the context of deeply divided societies, and that is that a consequence for relationships is that divisions and denial deepen. When you exist in a system of partial legality, and in particular when patterns of abuse disproportionately affect and are experienced by only one community within a broader community, incongruence is a reality only for some and not all. And especially when that incongruence, the lack of congruence, is denied by officials, then tensions can be profoundly deepened and exacerbates over debates, for example, about the role of police or security forces within a community. Why? Well, when one group suffering from and disproportionately suffering from incongruence is also historically marginalized or experiencing other forms of discrimination and marginalization, it's a common experience for reporting abuse to be met in the language of philosopher Miranda Fricker, what she calls testimonial injustice. When the testimony offered by someone is ignored or discounted or simply not believed because of who the speaker is. And in the context of one community within a broader political community in Northern Ireland or South Africa, when their experience as white South Africans or as unionists is one of where the police are disproportionately from. In Northern Ireland during the Troubles, 7% of the police were from Catholic communities. Experiences with the law are uniformly positive for another community. And testimony from those who are complaining is discounted in the ways that I've just described and not believed. Calls for reform then can be seen as either unwarranted or as a personal attack on the families from which law enforcement come or the communities from which they're broadly drawn. And finally, a consequence of the kind of erosion of congruence in the context that I'm interested in is that there's an erosion of the conditions and in particular reciprocity needed for law to function in any community. So Fuller points out that ongoing cooperative reciprocal action and interaction is needed between officials and legal subjects, in part because of the mutual restraint that governing by law demands in order for that to be possible. But that restraint in turn depends, specifically for legal subjects, on faith in law, which the knowledge of lack of congruence or particular publicized instances of it can erode, or other violations of the rule of law. And also trust, a willingness to take as a default presumption the lack of ill will on the part of those you're interacting with, and competence to engage in and fulfill role-related responsibilities. And violations of the rule of law are precisely one of the important sources that can disrupt the faith in law, and the corresponding willingness to trust and engage in the mutual restraint that the rule of law requires. So, summing up, why law? Why govern by law? Because without it, people suffer. Harms and rights that would otherwise be prohibited are much easier to commit, and because relationships are damaged, accountability and transparency are undermined, agency becomes more difficult, reciprocity becomes impossible, and conflict and divisions deepen. So what I've said up till now is only a very small part, maybe not even the most fundamental part, but a part of a much larger and more complicated story of the ways in which political relationships get damaged, that generate the need for transitional justice and reconciliation. A story which, to be complete, would also need to look at the substance of laws and not just the form that they take. The economic, social, and political institutions and the norms and rules structuring them within communities. The transnational aspects of current conflict and repression, both in their colonial era roots and in the contemporary forms that they take. And ideology, the tales we tell ourselves to understand the world we navigate and often to implicitly discount the injustices to which our attention is drawn. But having once diagnosed damage, of course, the next question then becomes, where do we go from here? And how might things be better? A common answer, a deeply American answer, at least to a dominant strain of American thought, is look forward and don't dwell on the past. That in the context of divisions and damage of the kind that I've laid out, dwelling on the past on this line of thought will only sow further division. And that's what we've done predominantly in our own history here in the United States. But the answer of the field in which I work and on which I've written different books on transitional justice, is if we want to go to someplace better, we can't simply forge ahead pretending the ugliness and injustice of the past didn't happen or doesn't shape the present. We have to, using the language of transitional justice, first look back in order to be able to reach forward. And of course, this echoes another strain of American thought, protesting and contesting efforts to put the past behind us. So why do you have to look at the past, especially when it's ugly, or the ugly bits of it? Well, one thought is that refusing to acknowledge or deal with the messiness of the past and how the past shapes the present gets communities nowhere. It doesn't make the past or its harmful effects go away or heal real divisions, which instead simply fester. That if we want to heal communities and get somewhere better than we are right now, we first have to understand what's damaged. And damage will only be repaired if it's acknowledged and addressed. And the thought behind transitional justice is a very common and familiar one in the context of most relationships, where you have to deal with problems in order for things to get better, and hiding or denying them only makes things worse. So how do we look back in a way that positions us to move forward? The wisdom of the collective practice and scholarship of transitional justice over the past decades is by pursuing 5 pillars. A pillar of truth, committed to documenting the causes, consequence, naming the victims and perpetrators of human rights violations in an official manner, needed against a background of denial and disagreement about whether human rights violations occurred, what the extent was, who was responsible for them, and who affected them. Justice, understood as accountability and most often equated with criminal trials, aimed at countering a culture of impunity surrounding rights violations which characteristically exists. Reparations, both material and symbolic, to acknowledge and begin to repair the harm victims suffered. And non-recurrence, institutional reform efforts to ensure that conditions of never again are materialized. And finally, memorialization, so that communities commit to remembering the past in an ongoing, enduring manner, including past atrocities, as part of a broader effort not only to honor victims, though also to do that, but also to ensure we continue to understand wrongdoing and prevent the recurrence of it in our communities. So against these pillars, my work of late has focused on addressing questions that they raise. I'm not claiming originality with respect to the pillars. But one question is, what's the relationship among them? So characteristically in the scholarship and practice as it's involved, all 5 pillars are seen as necessary and non-substitutable. Not an a la carte menu from which communities may choose. A little truth, maybe some justice, forget reparations, and we'll go for some reform and commitment to non-recurrence. So one of the things that I do in my book is articulate why those pillars are jointly necessary together and the purpose that they serve, arguing that the underlying concern that they're oriented towards is trying to fundamentally transform the social and political relationships that exist after systemic and widespread wrongdoing has occurred. And I go on to articulate the conditions that need to be in place for communities for this kind of transformative change to both be needed and also to be possible. Now I'm trying to think about a different kind of question, and that is, how should we think about the necessarily imperfect choices and processes of transitional justice that are chosen? So transitional justice remains intensely controversial in the communities where it's pursued and adopted, not only in pursuing it, but also in terms of the specificities of the particular processes that are chosen. And that's because, inevitably, not all perpetrators and victims are addressed. Inevitably, those victims who are addressed will not achieve or see perfect justice, leading to complaints that victims in these contexts are sold short. Nor are perpetrators punished commensurate with what retribution would seem to demand. Moreover, the impact of any single process, any single truth commission or scheme of reparations or institutional reform effort is quite modest, leading to complaints that instead of transforming communities, instead the status quo just gets re-entrenched. And so in my mind, the perfect should not be the enemy of the good. And transitional justice is a promising solution that we have to widespread wrongdoing when it exists. And the current project I have is trying to articulate the conditions that provide resources for distinguishing between cases when victims really are sold short versus cases where victims get a measure of justice even though that justice is not perfect or complete. The conditions that make the inevitable compromises that must be struck in pursuing transitional justice principled and defensible to do. Now, obviously, or if not obviously, I'll make it obviously, the story I've been telling is not just a story of other countries around the globe. It's a story also of us here in the United States. This is not surprising. We're part of the global community, and we are both shaped and shaped by it. In Northern Ireland, the civil rights movement that began to protest the segregation and discrimination explicitly drew inspiration from the civil rights movement in the United States. But more specifically, the concerns I've been articulating about the rule of law and its absence, about the way partial legality shapes the experiences of different groups within the same community, is an ongoing concern and reality of us both past and present here in the United States, as are the other forms of damage that I talk about in my work. It's the story of lynching, extrajudicial murder meted out by white vigilante mobs in the complete absence of any form of due process, and often with law enforcement either complicit in its commission or complicit by way of preventing its occurrence. It's at the core of complaints underlying hashtags like driving while black or living while black, where lists of the ordinary activities that, if done while black, and often while brown, can lead to a 911 call, or an arrest, or jail, or a fine, or getting threatened, or worse, getting killed, while you're driving an Uber, or having a business meeting in Starbucks, or existing in your own home. And against the background of the murder of George Floyd and the subsequent protests, it's at the core of conversations about police and calls to reform the police and alter the status quo. And finally, ours is a story shaped by very different realities in ways that are influenced by race in the experiences with law enforcement itself, of the impediments Black men and women face in being believed, and in particular by white Americans, when expressing concerns about the treatment to which they are subject, and about being believed in a way that doesn't implicitly presume some form of wrongful action must have preceded whatever incident is in question. Because the point of the hashtag, of course, is that nothing wrong was done other than being Black and living in America. And of the difficulty of having calls for reform heard in a way that doesn't equate complaints with disloyalty or personal attacks on a community. And like all the stories I've just shared, what I've said now is just a very incomplete sliver of the American story, which is, of course, much more complicated, and the challenges we as a deeply divided community face deeper than what I've just presented. But ours is also not only the story of damage that we find in other places, it's a story of trying to find ways of pursuing the pillars of transitional justice, though often such efforts fly under the radar of national and even local conversations. It's the story of efforts like the work of Brian Stevenson and Equal Justice Initiative as it opened the Legacy Museum 1 week ago. The story of the city of my birth, Evanston, Illinois, passing a reparations program to deal with legacies of redlining in that city. Now, some might say, Murphy, why'd you end on a political note? Or even if we see the efforts I've just mentioned as happening, isn't it simply hopelessly utopian to think that in the US right now, there's a place to pursue the goals and tools that I've just laid out? While we may disagree about many things, there is consensus on the depths of the divides along multiple lines that currently exist in the United States. And I chose that ending purposely, and I'll tell you for two reasons why. First is to underscore that transitional justice is inherently political. The circumstances of politics are one of disagreement generally, but specifically when pursuing dealing with the past in context of disagreement about the past and divisions because of it, and disagreement and divisions that are deep, emotional, and so the questions raised by transitional justice profoundly controversial, and against the background of widespread and often very recent loss, hundreds of thousands killed in some contexts, or emerging from a period of genocide, controversy is far from surprising. But secondly, and despite this, and far from being hopelessly utopian, communities divided as much as ours, and in some cases much more than our own, find a way, imperfectly, roughly, controversially, and not always permanently, to try to make their communities better by dealing with the past, trying to establish conditions where the past will not be repeated again, and from them we should draw inspiration. Thank you.
Thank you so much. Professor Murphy, I wanted another round of applause for her, and then I hope you will join us out for the reception in the Peterson Pavilion to continue the conversation. We want to celebrate her past achievements, but also look forward to the ongoing work and the future conversations that we all can have. Thank you and congratulations.